I'm Sarah Keogh, I'm a barrister at Old Square Chambers. I'm a specialist in employment law and I've been dealing with junior doctor matters for a number of years. The agreement provides protection to the postgraduate trainees equivalent to the protection available to workers under the extended definition in section 43K of the Employment Rights Act. So where a postgraduate trainee makes a protected disclosure and they believe they've been subjected to a detriment by Health Education England as a result, then they will have the right to bring a breach of contract claim against Health Education England in the County Court or High Court. The remedies they'll be able to claim there are exactly the same as a worker falling under section 43K of the Employment Rights Act could claim in an employment tribunal. Where a detriment claim is brought in an employment tribunal, the worker is able to claim unlimited compensation, which can include compensation for injury to feelings, and the tribunal can also make declarations that what has occurred is unlawful. The remedies under the agreement are exactly the same and they'll be assessed in exactly the same way. So that means if a postgraduate trainee successfully shows, for example, that they've lost their entire career as a result of Health Education England's actions, then they could claim career-long losses, subject of course to the usual principles of mitigating those losses by finding other work. I would add though that career-long losses cases are extremely rare. The compensation will also be subject to the other limitations which exist in the employment tribunal proceedings, such as a reduction in damages where there's contributory fault or where the protected disclosure isn't made in good faith. One question I've been asked a lot is whether the courts could order reinstatement under the agreement. Now, reinstatement is a term in the Employment Rights Act which specifically refers to resurrecting a contract of employment, and it's only available as a remedy in the employment tribunal in an unfair dismissal claim by an employee against their employer. Now, as we discussed earlier, the term employer in a whistleblowing context can be a bit misleading because it covers not only employees but also other types of workers, and only employees can bring an unfair dismissal claim if they're dismissed following protection disclosure, not workers falling under section 43K. There's no contract of employment between a postgraduate trainee and Health Education England. They can't claim unfair dismissal, and there's no contract of employment which can then be reinstated. Now, in certain circumstances, however, the postgraduate trainee might have a claim against both Health Education England for detriment and against their former NHS employer for unfair dismissal. Well, junior doctors already enjoy exactly the same protection afforded to permanent non-training NHS staff as against their NHS employer. What the agreement does is provide an extra layer of protection against any detrimental treatment by Health Education England, as if the postgraduate trainee was a worker of Health Education England under section 43K. A postgraduate trainee bringing a claim under the agreement against Health Education England will therefore have exactly the same level of protection as a consultant bringing a claim for detriment against their NHS employer, for example. The only difference is the claim will have to be brought in the County Court or High Court instead of an employment tribunal. For BMA members, the cost of the claim will be paid in full by the BMA, provided the claim meets the normal merit criterion of greater than 50% prospects of success. The BMA uses a team of specialist employment law solicitors who will apply exactly the same criteria to determine the merits of a claim under the agreement as they do when they're determining whether to fund a whistleblowing claim in an employment tribunal. So if they assess that the case has a greater than 50% prospect of success and it doesn't predate the doctor's membership, then the doctor will be eligible for discretionary legal support and full indemnity in respect of legal costs just as any other member would be.